Good afternoon, everybody. I'd like to thank you for attending our panel discussion today as part of the Entertainment and Sport Law Society's symposium. Today's panel is entitled Social Media as Evidence, New Legal and Ethical Frontiers. I'm Jason. I'm one of the co-chairs of ESLS, and today we're going to be exploring a number of legal issues related to social media and the law, and basically asking, can the law keep up with the torrid pace of technology? So it's my pleasure to introduce our panelists. I'm going to start with Professor Chonder. He's a UC Davis School of Law professor who specializes in cyber law and intellectual property. And then next to him is Catherine Kirkman. She's a partner at the Palo Alto law firm Wilson Sonsini, and she's a publisher of the Silicon Valley Media Law blog and an expert in media and technology law. And then next to her is Roger Dreyer, a Sacramento attorney who represented the plaintiffs in a high-profile lawsuit stemming from the death of a radio show contestant. Jurors in that trial were asked to sign declarations that they would not access any information about the case on the internet, and it's believed to be the first of its kind in California. And then over here is Cass Farinini. She's a partner at a Sacramento law firm, Downey Brand, and an expert in employment law. She's dealt with several cases that involve using social media as evidence. And then finally, Professor M. Winkle-Reed, who's a UC Davis School of Law professor, and he specializes in rule of evidence. So the panel today is going to be moderated by Senior Assistant Dean of Student Affairs, Hollis Colwin. And Dean Colwin has made presentations on law students and law schools' use of social media at the annual meetings of the Association of American Law Schools and the Law Schools Admissions Council, and at national conferences for graduate and professional schools and financial aid professionals. Previously, Dean Colwin practiced law for 10 years, specializing in business litigation. And now it's my pleasure to hand it over to Dean Colwin.
Thank you, Jason, and thank you to our wonderful speakers for coming today. In order to give everybody an opportunity to share their thoughts and still have some time for Q&A, I've asked our speakers to limit their remarks to under 10 minutes, which is a shame because all of them could easily fill up an entire hour. Professor Chender will begin because he has to teach at 12:45. And speakers, if you see an exodus at 12:40, those are his students going to class. So let's start with Professor Chender.
And except for the one person whom I've already excused, I expect to see you there. Hi. I want to make two brief observations, one about the future and one about the past. The first is about the future. One of my friends, a woman, which is also partly about the past, a woman whom I went to college with, is now been nominated to a federal district judgeship in the Northern District of California. This nomination came down last week. And, you know, I imagine this will happen to you. You or one of your friends that you knew, this is the person I knew from college, knew from law school perhaps, will be nominated to a very important position. And of course, in that process, everything that is known publicly about them will come to light. We, of course, grew up in an age without Facebook, without these kind of social media that recorded all our interactions with each other, in which our interactions were written on something that could be preserved till the end of our lives and into our children's lives. But one could have easily imagined this woman saying something, you know, during college or in law school, you know, so-and-so is the worst senator since, you know, since the, I don't know, I can't identify terrible senators that everyone might agree with. One can imagine all kinds of politically charged things or otherwise controversial things she might have said offhandedly. And that might have made her a kind of too controversial to actually appoint to this position, to nominate and confirm for this position. And of course, that means either that we live our lives now under a straitjacket, not saying anything potentially controversial, haunted forever by the possibility of constraining our future decisions and our future opportunities by that possibility. Or we take the risk of being true to ourselves, you know, exploring, taking chances today. And that chance-taking is, I think, at risk in the future. The second point about the past. Well, I don't think we should be, we shouldn't be so, we should expect that technological change might require us to revisit the law itself, the existing law. And I begin by pointing out that it was actually technological change that led to the common law rights to privacy that we have today. The common law rights to privacy that you are aware of, these common law torts in state law, arose because of technological change. In particular, the article called "The Right to Privacy" in the Harvard Law Review, 1890 article that is said to have launched the common law right to privacy, was largely the result of the developments in photographic technology. Before Warren and Brandeis wrote, earlier, the technology had required you to pose for a portrait. And so you recall, you would have to stand very still. Not you recall, but you've seen the images, et cetera, of this. And so you would have to stand very still. But Kodak introduced this kind of instant camera that could catch you while you were walking the street. You could have a picture taken of you without your consent. Right? And that is exactly what launched Warren and Brandeis to assert a right to privacy. And so the common law right to privacy that we have today actually owes its existence to this technological development. The fact that new technologies mean that all of us, there are probably as many cameras in this room, or actually more, than the people who are in here, because all of you now are carrying these multimedia devices that can record my voice and my image at all times, and record that of your colleagues and friends. I think all that requires us to be extremely cautious about the future. Thank you.
Great. So I brought a social media management checklist that hopefully has been handed out. And what I wanted to do is provide the perspective of an IP lawyer, IP commercial lawyer working in Silicon Valley with companies that are making social media happen, and how they try to navigate the issues that we're all talking on this panel today. Because you look at any individual issue or user liability issue, company liability issue, and sort of get lost in that. And you have to helicopter up a little bit and assess a strategy and risk management. Because no, the law sort of is never keeping up. The DMCA was enacted in 1998, and that was when Yahoo was this sort of hierarchical thing, which still works today. But when we think of information location tools under 512D of the DMCA, we think of Google, but it's all the same thing. And 512C for hosting was for, I don't know, GeoCities or something like that. And that's sort of, that's the essence of YouTube in terms of people being able to put their stuff online. So what I wanted to do is, one, speak a little bit to my perspective, and then talk about a couple use cases here. So in the IP life cycle of a new startup company, well, one, they have to have a great vision, product, all those things, and they have to have built it and have the IP to that to go into the company. But in terms of the business model, in order for them to get venture capital or otherwise raise money, people are going to do diligence on the company and their IP position to find out, well, what is the story? How can they do what they're doing? I mean, back in the day, we worked with Napster, not in the litigation, but in the company when it was trying to get licenses. So that's an example of one that didn't quite work out for various reasons in terms of how the missile was pointed, I guess I would say. And then on the other hand, YouTube, who we worked with from the very beginning, was very clear about their strategy around the DMCA in terms of hosting content for users, and if it's infringing, to take it down at the request of the copyright owner. and we worked with them until we sold them to our other client, Google. So companies have to have a practical strategy with a reasonable degree of risk that can stand up to scrutiny, but also reflect that in terms of the opportunities, you have to manage around a certain level of risk. Otherwise, nothing is ever going to happen. We're not going to have any social media. We're not going to have any social media companies. If any of you have uploaded doppelganger photos to your Facebook, have you cleared all the rights to that? What are you doing with the right of publicity of that star? I mean, so we can, and I'm not minimizing that issue, I'm just highlighting the extent of the issue. And then imagine if you're the platform providing that, there's really no way to manage that unless there is a legal regime that allows you to respect IP rights and take things down with proper notice as to where the infringing items are. So, so that's the perspective that that we bring. And then these companies, they grow up, they get good IP management practices. It's not a one-time come to Jesus or whoever thing. It's an ongoing hygiene of good practices. And then over time, they grow into whoever. They go public. Yes, there are some IPOs coming back now. Mergers and acquisitions are really the main exit now for people pursuing that. And so, if a client comes to me and says, how am I going to, launch my company? And if I just say, well, you have an SHIT load of issues, good luck, that's not going to really help, because they need to be benchmarked around sort of best practices in the risk management. For example, with the DMCA, there's the letter of the law, there's the hygiene you have to do to register with the copyright, et cetera, et cetera. But there is also best practices in terms of what has happened realistically with major content owners who have valuable IP, record companies, TV shows, et cetera. And there are different conversations, different digital technological management systems. There's a lot going on there in terms of best practices that evolve and that over time, are continued to be maintained and improved. So not a one-time thing. If we think about YouTube, if you remember, when Lazy Sunday came out around Christmas, I mean, who knew that was going to be so popular? And they took it down when NBC asked them to take it down, and that's just the nature of the world we live in. And now, SNL appears to be pumping out these digital shorts. So it's interesting how the world sort of evolves to new norms, if you will. So just to speak briefly to this checklist is a cross-disciplinary piece of work. There's, people just don't want to hear about problems. They want to hear about how they can manage their company in social media in a positive way. Obviously, if your product is social media, if you're Twitter or something, that is job one. But if you're Volvo, if you're Coke, Coke, how many fans do they have on Facebook? They've got a ton. You want to have a strategy, and then you want to have risk management, because if all it is risk management, then are you missing the boat? Also, another example is a company that actually is a major content owner, a major broadcaster with an interactive division. And how do you not miss the boat on social media? How do you take those Twitter and all those opportunities and build out the brand and your editorial product and mediate that with your talent? When are they working at, representing you? When are they doing their own thing? It's really interesting. But, the main thing is it's a gigantic opportunity that needs to be grokked and strategized and managed. So let me just speak high level So that's how we present it. And then, you know, social media policies, that's a big deal these days. We're going to hear about employment law. So employment lawyers have a stake in this. Marketing, advertising, promotions. FTC consumer lawyers have a stake in this. Editorial content, that means, you know, the company's content. UGC, that's the user-generated content. That's copyright. That's DMCA. That's the CDA, which allows a platform provider not to be liable in connection with defamatory statements and the like. And then, you know, consumer privacy. Again, that's the FTC. And then just the whole ball of wax in terms of IP. Oh yes, and corporate lawyers. I mean, Sun has had their executives and everybody blog, you know, from, I don't know, for as long as I can remember. And so, but if you're a public company, there can be issues with that. And so do you just say, too many concerns, don't do it? Maybe that's your analysis at the end of the day. Or maybe it's, no, this is something that we think is valuable and we are going to manage risk around that and have a clear strategy that is rationalized and have some employee HR policies around employee blogging, for example. And then, you know, you think you have it nailed, but then you realize you're just talking about the United States. So this really successful startup then starts thinking, well, what about England? What about Japan, right? And so from day one, you're really looking at it, unless they are launching in those country-specific locales, from a U.S. perspective, because the DMCA is pretty good and other countries maybe aren't quite as good. Then you have to think and roll out strategy around those entities. Can you be sued there? Do you need, subsidiaries to be the focus there? And, you know, what is their legal regime? And so that's just, so I brought this because I thought it might be useful to think about it from the perspective of those companies that are, you know, trying to make social media happen, notwithstanding that it's fraught with issues. This is actually 10 pages, but we're politically, we're good on trees, so it's double-sided. That's me.
Thank you.
Yes. Well, the first thing, I wanted to kind of make this as practical and helpful to you as you go out after you finish your studies here, and some things to think about in terms of being lawyers. And one of the things, Dean, that you might have considered if you do this again is putting a professional responsibility professor on this panel. Because one of the big issues that we deal with as lawyers, the three of us when we're practicing, especially when we're doing discovery, is what we can do and what we can't do. And right now with technology, I'm probably one of the oldest people on this panel, so I remember before the Discovery Act and how we went about our process of getting information and how we do it now. But technology, we see it every day in the news, how text messages and emails are disclosed that people certainly never wanted to have disclosed. And what are your expectations of privacy, and what really is privilege and what isn't, and what's going to get out there. Now, for people who are doing things that they don't want to have public exposure on, that's the risk every time they do a text message or an email. In litigation, it's something I deal with all the time because I have clients who are injured, or I have clients that have suffered an enormous loss in their life or family member. And the other side has unlimited resources, and the larger the event, the more potential exposure, the more money they're going to commit to it. And there is tremendous game playing, and I'm sure Kathy, in her side of the industry, when businesses are suing businesses, they're not real good about producing information that's asked for in discovery. And there's a recent case that just happened down in Southern California where a number of very, very prestigious lawyers have just been turned over to the state bar by the federal judge, the magistrate who was handling discovery, because they did not produce information that was, was probably discoverable and asked for. And they trusted House counsel, inside general counsel to make those decisions, and they ended up, carrying the weight of the consequence of failing to provide this information. So you as young students, soon to be lawyers, you're gonna be facing this technological challenge of how far you can go to get information. Do you go on Facebook? Do you go on MySpace? You'd be absolutely shocked, I think, by the level of intrusion that can be brought into your personal lives. So if I have a client, I've had this happen many times, I have a client who has a horrible leg injury and an arm injury, and then we find out through discovery, because now we go on Facebook on our own clients, and we go and try to get everything we can, that's Google them, we do everything we can, because we know the insurance companies are going to do that. And when you find out that your client is posting on his Facebook that he's a member of Vados, which is a motorcycle gang, or you have a client who has a back injury and you see her jumping on a trampoline, these are things that fit with exactly what the insurance company in our climate now wants to present, that everybody's engaging in fraud. Well, the fact that someone has a back injury doesn't mean they can't get on a trampoline, because you don't know how they felt immediately after that. In the early parts of my career, we were always dealing with surveillance, where they would, follow people around and watch them mowing the lawn, and then somehow that makes it clear that they're not hurt. So this is something we're wrestling with, is how intrusive can we be? And then when we're asked questions about what we have, because under the Discovery Act, the whole idea is it's not a game of chance, and it's not supposed to be a gotcha world. It's supposed to be an honesty world. And the case law out there presents very clearly that lawyers have a duty to act in an honorable, honest fashion, not to be deceitful and not to withhold information. That's your duty. And there's cases that deal with it, and when you get out in the real world, you're going to deal with lawyers who don't follow that concept. And the issue is, are you going to follow it? And how do you follow it? And this is something we expect of our clients, we expect it of jurors, but you also have to expect it of yourself. So in our world, if someone asks us for information about our client, if they ask us for Facebook, they ask us for photographs, because we are, photographs now, everybody in this room, I'm sure, has a camera. That never used to be the way. And we just had a discovery request where they asked for all photographs of my client from the date of her injury to the time of today. She's had 2 surgeries, spine surgeries. And she produced 1,500 pictures. And these 1,500 pictures are not with her bending over in agony and not being able to do well, because pictures are a very static, a fraction of a second moment in time. So she may smile and have a beer in her hand with a buddy, and then the next, she's leaving the party early. Well, you can't explain that to a jury. That visual impression is very powerful. And so you need to be aware of that when you represent your clients, and you tell them, we tell them, you've got to be careful, you're being watched. And now it's much more easily accessible. In the criminal world, there's a recent article that's come out. It talks about what we don't realize has happened since 9/11, and the access that the federal government has had to our phone records. And it's well beyond alarming. The federal government has developed a very close relationship with all these companies like AT&T and Verizon and others, and it really, initially it started with they had to have good cause, or they had to have a subpoena. Then they were taught that all they needed to do was write a letter, which is called an exigent letter, which we need this stuff right away, we're going to follow it up with a subpoena, which they never did. And they got access to all sorts of information about people. And I don't know if you appreciate when you text that information can be stored on your SIM card or not. And if you text somebody, what's going to happen in terms of that information getting out to somebody else? Now, a lot of this stuff can be very innocent, but it is a tremendous available resource for us as lawyers to get. You have the right to get it. And if you think that everybody's going to be very, following the rules, you're mistaken. So we send out requests for information and discovery. We get answers. A simple example is when you have experts in a case and you communicate with your expert, do you send him an email? And do you have a good relationship with the expert? And do you send the email, Dear Bob? And do you discuss strategy when you're talking with this expert by way of email? And then when they make a request for the deposition of your expert, and they ask the expert to bring all materials he has, all communications with counsel, and the expert doesn't bring emails that you know that you've sent, are you supposed to tell the expert to bring them? Are you supposed to volunteer that your expert has emails that he hasn't produced or she hasn't produced? And when an email is shown where you call your expert by his first name in front of a jury, hey Bob, how you doing? How was the vacation down in the Bahamas? Sorry to bother you, I really need you to come through for me on this case. That creates a spin on the presentation that is maybe not what you're looking for. So, and I'm sure Cass is going to talk about this in the employment context, because people don't appreciate all the things they're doing while they're at work and using the social media. So as lawyers, you came to this, I'm sure you're members of the evidence class to show your professor how interested you are, or Professor Chandra's class. But as you go out and be a lawyer, this is really a very, very evolving area that we don't know the rules. And a lot of it's going to have to be really subject to your good judgment and your ethics. And not wearing them on your sleeve, but how you really, who you want to be defined as and what kind of a lawyer you want to be. Now, the thing I think that resulted in me being invited was the Jennifer Strange wrongful death case that was very well publicized since her death back in January 12th, 3 years ago. And that case was this is a great example of social media, because there was an enormous evasion on this family. And everybody went on the internet, and if you Google or you go on the internet and type in water intoxication Jennifer Strange, you'll get 63 hits, 63,000 hits, excuse me. If you go in and you do water drinking contests, you'll get 80,000 hits. And if you type in Jennifer Strange, you'll get 40,000 hits. There's so much information out there on this case, and a tremendous invasion. In California, if there's a wrongful death, the spouse is able to go to trial, and there's no evidence that's presented whether that spouse has ever dated anybody, gotten married, anything. It's because it's irrelevant, and the law determines it's irrelevant, because you don't know what would have, you can't assume that he would have done these things or she would have done these things but for the death of the spouse. So the law says you can't discover that. You can't ask him whether he's dated. But and we discussed this with my client. I said, anything you do is subject to discovery. They can catch you on a picture. You need to expect them to hack into your system. You need to know that they're going to try to get information about you. So you need to tell clients that sort of thing. But in this case, because of the volume of traffic on the internet, we decided strategically that we needed to deal with this right off the bat with the jury, because I've tried over 100 civil jury trials in my career. And jury misconduct is the worst thing that can happen to you. And some of you in here may end up trying cases, and you might have the privilege of doing that, but there's nothing worse than being in trial for 2 weeks, 2 months. I tried the Oakland Raiders case. I was in trial for 6 months, and having jury misconduct, because it all goes down the drain. And it can be something that they don't even appreciate that's misconduct. And getting on the internet is something that everybody does all the time, so they do it. And they don't even know that they're violating it. I'm not supposed to talk to anybody. I'm not supposed to go out and do any research. I'm not supposed to do any investigation. All right, well, I'm interested in water intoxication. I've never heard that before. Juries make a disconnect. We're not dealing with, university students or people in professional schools. We're dealing with some people that, don't even have a high school diploma. And they view things very simply sometimes. And that's not demeaning those people. It's just a reality. So we had a declaration that the jurors had to sign before we even started jury selection. If they were going to be on the jury pool, we had over 200 people on this jury pool because of the exposure. So they all had to sign a declaration that said, I promise, and I'm setting it down here a little bit more succinctly than it was. It's much more expansive. I mean, we named every social media that we could think of. And he said, I promise I will not do it if I'm on this jury panel. And everybody wanted to be on that case. It was an amazing case because generally people are trying to get off cases that long. People were standing in line to be on that case. But we did have some people say, I can't sign this declaration because I don't know that I really think I can do it. Because it's interesting, people are very willing to violate, they think, but as soon as they get empowered to sit on a jury, their attitudes change. They really do respect it for the most part. But we also had them sign a declaration. We told them, not only are you going to sign this declaration, but when the case is over and you bring in a verdict, you're going to have to sign another declaration that says, I tell you under oath that I have not been on the internet. And I promise you that under oath that I have not done that. So I honored my promise. And I will tell you, the Roger Dreyer humanistic, hopeful side believed that they meant it. The Roger Dreyer cynical, I want to protect my verdict no matter what side, I wanted to have evidence that they said under oath that they didn't do it. Because I knew that if we got the verdict that we got, that the insurance industry would be in their houses trying to convince them that there was some misconduct, because it was a very difficult verdict to reach. So what lawyers do and investigators do is they go and they interview them and they create a declaration that demonstrates misconduct, and it's absolute misconduct, verdict gone. I went on the internet, or Joe Blow went on the internet, told me he went on the internet and researched this about Billy Strange or researched this about hyponatremia. Case is gone. So I knew that even if they did commit misconduct, they wouldn't tell anybody they did because they signed these declarations. And I also knew that if they signed a declaration that said I did do it, I got a declaration that says they didn't. And that'll be enough for the judge to say I'm not going to throw it out. So it had a practical application, but it also had a really important application. And you'd be amazed how many judges have called me, criminal judges, for the most part, not civil judges, have called me and have asked me for these declarations and the points of authorities because they want to use it. And I know that the federal district court, their big committee that sets forth rules on what they're going to do, just last month had a meeting, the committee on setting forth rules for the district courts in the country that deals with this specific issue about jurors, because there's been so much misconduct. There have been so many cases have been thrown out because of jury misconduct. So that's something we decided to do, and I think helped us a great deal, and obviously helped us preserve that verdict.
Thank you. Yes?
Well, I'm an employment lawyer, so a lot of my job is basically policing the playground. I think that a lot of the things I see wouldn't have happened if somebody would have just been taught manners when they were 5 years old in kindergarten. But I wanted to give you an idea of how I am seeing this evidence coming into my practice, how it's being used. And I'm seeing it mostly in sexual harassment cases, privacy type cases. Obviously in the policing aspect, you get calls from clients. I have 2 employees and they're battling it out on MySpace and the other employees can see it, and can I punish them? Can I discipline them? Can I terminate them? Or I have an employee who's blogging about how my customers are evil and my business is bad. Can't I do something about this? And sometimes the answer is no, you can't. There's a law in the labor code in California that says you're not allowed to discipline employees or punish them for lawful off-duty conduct. So there's a lot of questions that come into my practice from this. And some of the characteristics of this evidence as opposed to other evidence I find absolutely fascinating. For example, for many years in a sexual harassment case, it's he said, she said. He said yada 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 in my ear verbally. We were the only people in the room. No one else witnessed it. Well, when this conduct is happening via text message, not only do you have the exact content of the communication, if you have an iPhone, I'm sure you've all seen the iPhone interface, which actually shows you via little thought bubbles the conversation that you can put on a photocopy machine and photocopy and blow up into an exhibit for use at trial. And the great thing about these text messages, particularly on the iPhone, is you've got the date and time. Okay, so I know this happened on Monday at 10 in the morning. Exactly. Happened Monday at 10 in the morning. They were at work. This was on-duty conduct. This was in the workplace that this occurred. Also on the iPhone, you have the name of the person who's sending you the incoming messages. So you've got that name prominently displayed. It's just a beautiful exhibit. And so there's no question of what he said. And I've had text message strings from an iPhone that establish almost all the elements of a hostile work environment harassment. You've got a proposition that's clearly, you know, inappropriate and dirty. You have the response saying, this is inappropriate. Which means, hey, was that a welcome communication? No, she said it was inappropriate. And then, here's the other thing, they always come back with something stupid when a girl says it's, and I'm, you know, I don't mean to gender stereotype, but, you know, when she says it's inappropriate, the commentary is just not good after that. The other thing that's interesting about the text message evidence is people are now talking in non-words. You are this, that, or the other thing. Or, you know, you use this kind of shorthand when you're texting because you're too lazy to type out the whole word, and it frankly makes you look like you're inarticulate. So, as a piece of evidence, it's like, gosh, not only is this guy engaging in horrific sexual propositions, he's a moron. So we're seeing that sort of thing. The other thing is, like with email, a lot of times your responses via text message, via email, are impulsive. You don't get a letter and then sit down to write a letter back. This is an instant form of communication, and particularly with the IMs that go on. I mean, your response is instantaneous. If somebody doesn't respond to me, if I'm playing Farmville and I get an IM, I feel like I need to respond to that pretty quickly, or they're going to think I'm ignoring them, I'm mad at them, I don't care about whatever issue they just raised. So there's a impulsivity to the communication as well. People are not considering what they're putting down on paper, electronic paper. And there's a permanence that people don't understand, that when you delete a file from your computer, that file sits there until it's overwritten. You can delete something from Facebook, your Facebook page. It's my understanding that that information also still sits there. You can delete your text messages, but they're probably still sitting on a server somewhere. And just this week, we had a trade secret matter where some gentlemen who were working for a company were competing with that company in a bidding process. And they had their phones, which were company-issued phones, and the text messages went through the company's server, so there was no need to go to Google and beg or anything for that evidence. And so the company could see this string of text messages showing their anti-competitive activities, and also what they thought about their coworkers and how they didn't want to have lunch with this one or that one. I mean, it's just an amazing wealth of evidence, and people don't realize that that stuff can get pulled off months down the road and used against them. The other thing I wanted to address was the issue about defense lawyers and their volumes of evidence when they're asked for things in discovery. I represent a lot of companies, and you get a discovery response, and a lot of times I've had cases where they're asking for electronic evidence that it could be stored on 50 different servers in 50 different states. And so as a practical matter, sometimes obviously you try to be thorough and you try to do searches electronic searches that are going to capture all of the relevant documents for production. Sometimes that those emails that you're asking for are only on backup tapes. And so to get those emails, you've got to put them onto a hard drive and have somebody search them. And so this whole process of managing electronic evidence when you're dealing with large companies can really be a nightmare. And so from my perspective, you know, what I'm always hoping is, I hope I've formulated the right searches and talked to everybody involved to get me the right information and looked in all of the right places, because it's prolific. You have so much more electronic information than you ever had when it was a matter of printing things out. So that's my perspective on the kinds of things I'm seeing and the kinds of ways in which we're using this kind of evidence.
Thank you.
I'm really a bit embarrassed at this point. The other panelists have been talking about exciting radical developments. Professor Chander talked about the need to alter the law. Ms. Kirkman referred to the fact that the law is not keeping up. But truth be told, from the perspective of evidence law, the news is rather boring. Because the truth of the matter is, evidence law itself is adapting very nicely, thank you, without any reforms. And what it really leads to is the question of the way evidentiary rules are stated in things like the Evidence Code and the Federal Rules of Evidence. And what I'd like to talk about is the drafting of the Federal Rules of Evidence, because in the late 1960s and early 1970s, when the rules were drafted, the drafters made a very sound decision to draft general, flexible principles. Not to try to micromanage, not to try to anticipate technological development, but rather to give us general, flexible principles that would allow judges with good sense later to do the adaptation. And what I want to use is just two objections that sometimes come up to social media evidence, namely hearsay and authentication, to demonstrate how the law is adapting to these technological changes without really the alteration of the rules. Now let's begin with hearsay. Hearsay is not proving to be a serious barrier to the admission of social media evidence. In some cases, it isn't hearsay at all. It's only hearsay if it's an assertive statement used to prove the truth of the assertion. Consider, for example, libel. A libelous, slanderous statement posted on social media. That's not hearsay. It's a verbal act. The last thing you would want to do in a libel case is prove the truth of the allegedly libelous statement. You've just proven an affirmative defense and destroyed your own prima facie case. So the hearsay rule is not going to be a bar at all in those sorts of cases. Alternatively, in many cases, the statement that's posted is logically relevant on a different non-hearsay theory, namely mental output. It's circumstantial evidence of the state of mind of the person who made the posting, and once again, the hearsay rule is wholly inapplicable. Now, even if you assume that you have an assertive posting that's being used for the truth of the assertion, in a large number of cases, there's going to be a readily available hearsay exception, such as admission of a party opponent. If you're in litigation against the other side, they've posted something that is logically relevant to the merits of the case, it's almost automatically going to fall within the scope of the admission of a party opponent exception. And think of twittering. People describing what they are then doing, conduct they are then engaged in, that's a perfect situation for applying the present sense impression hearsay exception. I'm doing this now, I'm describing what I'm doing, it's technically hearsay, but it immediately, easily slips within the parameters of that exception. Now, the other evidentiary objection that comes up sometimes with respect to social media evidence is authentication. Let's talk about that for just a couple of seconds. If I go to my mailbox after this panel, and I have a memo signed by Dean Coleman, in everyday practice, what am I going to do? I'm going to assume that it in fact came from that source. I can't do that in a court of law. The common law said we won't accept things at face value. The Federal Rules of Evidence say the same thing. And so there is a requirement for extrinsic, independent, authenticating evidence. But it's a minimal common sense standard. Is there enough evidence to support a bare permissive inference that in fact it is authentic? And based in large part on analogies to email law and web posting laws, there are lots of different theories that you can use to circumstantially authenticate social media messages. For example, admission of a party opponent. After the posting, someone says something acknowledging that yesterday I posted this message. That admission, even if it's oral, is admissible and sufficient to authenticate the prior posting. Later consistent conduct. Someone describes what he or she is going to do in a posting. They later do precisely that. Later consistent conduct has been deemed sufficient to authenticate the prior message. Let's shift from after to before. Suppose that they indicate beforehand that they intend to make a posting of a certain tenor. That's a statement of present state of mind, a statement of present plan. Once again, it's routinely admissible and sufficient to do the authentication job. Alternatively, you can demonstrate that the information in the message is something known only to that person or to a small category of persons. There's a permissive inference there that the person who purported to be the poster was the poster. And if all else fails, you can subpoena the business records of the social media companies. They will qualify as business records under 8036 of the Federal Rules. And by virtue of the 2000 amendment to 902, you don't even need live testimony to get the records in. Now they are self-authenticating if you simply have the right certificate appended to the records. I think if we step back and take a look, what we ought to think about is a remark made years ago by the late Ed Cleary. Ed Cleary was the reporter for the Federal Rules of Evidence, actually the person who wrote the Federal Rules of Evidence. And Ed famously said that when they sat down to draft the Federal Rules, this was their choice: a creed, a catalog, or a code. A creed, a statement of general policy considerations and some aspirational objectives. A catalog, very detailed regulations of evidentiary issues, such as the one you often find in the California Evidence Code. Or thirdly, a code, a statement of general, flexible principles, and an act of faith in the capacity of sitting judges to carry out those principles and adapt them. And I think in retrospect, we should be glad that Ed and his co-drafters had the sense to opt for a code. What they've given us is a set of general, flexible principles that have been easily adapted to fax, email, web postings, and now to social media. And I think the real lesson is in terms of drafting in an age of technological change. It is probably a mistake to try to anticipate all sorts of technological changes and regulate in detail, micromanage what the solution is going to be. Technological change is too fast and too unpredictable. What you need, as demonstrated by the experience with the Federal Rules of Evidence, is a wise statement of general flexible principles and then an act of faith in the intelligence and sense of the judges who are to implement those principles. If Ed were here, he would say, in an age of technological change, don't go after a creed, don't go after a catalog, draft a code. I think it was the right thing to do in 1975, and our experience with technological change in the intervening years, I think, has borne out the wisdom of Ed's choice.
Thank you. Well, that's all very thought-provoking. Questions? If not, I've got some. But you go first. Questions? Okay, okay.
I've been using textual mediums for a decade or more at this point, and I was just curious because 90% of human communication is not conveyed through text. But in this day and age, a lot of people use things like sarcasm in text messages. They just don't really show up when you pull them up before a court and go, look, they said this. And so I'm kind of curious how the rules of evidence can help with that, or, because the rules of evidence are trying to get the truth to the trial, at least in theory. And so is there a way that the rule of evidence help interpret those? Or
The issue in terms of the rules of evidence are twofold: authentication and logical relevance. logical relevance, the judge is going to accept the statement on its face and say if it's a matter of interpretation, it's a question of weight. You can argue that to the jury. As long as it is rationally susceptible to the interpretation the proponent is urging, I'm not going to sustain a 401 objection. Then the battleground will probably shift to authentication under 901, 902, and based on one of the techniques that I was talking about, in most cases that objection can be easily overcome. But just as you would have a question of fact at trial, a question of the weight of the testimony, if someone took the stand and said, that wasn't what was in my mind at the time, you're going to have that question of fact. And again, the only limited function of the judge is to decide that that text, that language, is reasonably susceptible to the interpretation that your client wants.
And that results in the jury's job of deciding, is it sarcasm or did they mean it? When Cass's employer wrote the sarcastic, or he said it's sarcastic when the claimant is saying it wasn't.
And that's an excellent point, because the rules are drafted to respect the role of the jury. It's a question of Jacksonian democracy. We want the jury to have as much real fact-finding power as it can wield. We do not want, as Andy Jackson would say, these aristocratic judges usurping the role of our jurors appointed under the 6th and 7th Amendments.
Justice Thomas recently made a comment to wave the flag for anonymous speech. That it's not necessarily a bad thing to be anonymous. Some writers use pen names quite a lot, George Eliot, Tiptree, all sorts of people. You can build a reputation as an anonymous person. You can build your own credibility. A lot of the issues we hear about now is about the fact that anonymity is seen as a bad thing, and therefore there has to be this transparency between you, the private person in front of the computer, and the public who you are interacting with in Facebook and Twitter and the rest of it. If you're anonymous, you're a terrorist, a drug dealer, a pervert. There's a sense that anonymity is wrong and bad. You got any comments about whether anonymity might actually help?
I think it absolutely helps. I can tell you that if to separate your professional life from your life is a good thing when an employer can Google and get information about you. I know that there are instances in which we've Googled, not my firm, but my clients have Googled people, and you look at their Facebook page and their hobbies are, for example, binge drinking. Okay, is that somebody that you want to hire? And so I think a lot of people do use pseudonyms when they Facebook or whatever, and you can choose to do that or choose not to do that, and you know, who would know the difference? But I think that there is a value to anonymity, definitely.
There's a level of cowardice to it as well, and I think it goes back to the evidence issue. You know, it's fine if people choose to do it, but it doesn't mean that it's ever going to be used in a court. If you read any of the blogs, like when we were trying this case, the blogs, if you paid attention to what people were blogging, you'd want to go kill yourself because you had no chance of winning. Because you know, when people are anonymous, they're able to say anything they want, and there's no accountability for what they say. But freedom of speech allows us to do that. It's a good thing. But the issue is it ever going to be utilized in a courtroom? But my experience is anonymity is very dangerous and has the ability for people to spread lies and rumors that are not true. And people, I mean, we read the newspaper, we believe that what they tell us in the news is correct. Unless you're watching Fox News, and then that's another issue. But the reality is who's giving you the information, and if it's someone who's anonymous, there's really not much accountability for what you're saying.
Yeah, one thing I would just add is that if you're not familiar with the EFF, the Electronic Frontier Foundation, that's very important. Sort of cornerstone to their activities in terms of supporting anonymous speech for free speech reasons. I don't disagree that people, if they don't feel that they're personally accountable, that they don't take as much care with what they say. I sort of assume that somehow people can always find out who you are. Maybe that's wrong, but I do think that in terms of, I think, Roger, what you were saying about how you present yourself online, the idea that I don't know, a law student wouldn't want to share their thoughts on cases or whatever, that to me is a shame when I think about my teenager, wanting to get into college, when we have these rich tools for communication, and can't there be a way to use them that's appropriate? But we do work with Second Life, and I think that Linden Lab, that also anonymity provides the ability to assume different persona, avatars, etc. So there's a lot of creative, expressive reason for anonymity, and I think it's sort of a bedrock First Amendment principle, as you said.
Yeah, absolutely, it's appropriate. The issue is, in our world as lawyers, you have to be able to deal with information. You got to be able to prove things, and ultimately in a court of law, it doesn't happen very often, but ultimately it does. But my own personal experience is that anonymous speech can be very helpful. It can be, I've gotten anonymous tips through the internet where someone will say me something. I've gotten a picture sent to me that no one signed when they sent me the picture. That proved to be the key thing for me to winning a case. I have no idea who sent this picture. But the reality is the picture doesn't come in unless I can authenticate the picture and I can establish when and where and what. But I've just seen a lot of people hurt, because especially now people with bloggers and the ability to get on and say whatever you want and you don't care, and people read it. A short little quick story is that people were constantly or on these blogs when the Bee would write a paper or an article, and they would blog on about how stupid Jennifer was, how she deserved it, she was a horrible mother, didn't she know, all these just horrific things. And my 12-year-old client was reading them, and he blogged, he responded, and he said who he was, and he laid into them, and said that, said some stuff that could potentially have been very bad for me. Like if he had said, they deserve it, and I hope we get millions and millions of dollars. It could totally taken out of context by the reaction that he had to it. But it's part of our world. We have freedom of speech. It's what makes, with democracy there comes a price in a lot of different ways. And that's reality.
Sorry, but let me add one thing from the perspective of the service provider, which is the service provider does not have the obligation to allow anything on their service. So when you think about the issues, there's, as an IP lawyer, there's what are the IP rights, what is the technology, the DRM that can be used, but contract is a very important part. There are terms of service and privacy policy that I'm sure you've all read very closely or clicked through and all of that, but those have been upheld as binding contracts if they're done right and if they're not over the top, unconscionable, and those, as you know, have acceptable use, have different requirements. So, and they're also written flexibly to sort of cover stuff that, just doesn't sit right for just bad conduct, whether it's spam or whatever. So the service provider, that's their business, and they, preserve that in terms of the contract with their users. And then also when they're providing a platform, as you know, you can report inappropriate content, etc. So the community plays a role in that as well. So there is, I can put up my own thing and nobody can tell me what to do, if you will, but in terms of participating in some of these social media communities, at least there are some ground rules to make them, hopefully civilized.
I'd like to thank our panelists for today. I think we've run out of